ad tech industry lost that kind of, oh, we're not processing personal data anyway kind of argument. So there were a lot of changes, coming to the fore, and GDPR regulated the processing of personal data. So suddenly that collection, that use, the disclosure, the dissemination, and the general sort of uses of data now required that ad tech processing was fair, lawful, and transparent, and a real new sort of concept to think about. And in particular, it was difficult because there was already other law in place in Europe, and that's the e-privacy, which you were mentioning. So when you're thinking about ad tech, you're thinking about two things: the collection of data, how do you come across it in the first place, and then the use of that data. So e-privacy generally impacts the collection of that data. It's essentially the rules that the cookie laws. They're the rules that lead to all of these cookie banners that we see. And the new focus on e-privacy was important, partly because businesses were looking at privacy in another way, but partly because the GDPR changed the interpretation of some of those e-privacy rules. So e-privacy regulates the storing or gaining of access to data on an end user's device. Essentially, if you're going to grab a cookie off a device, you're gaining access. If you're going to store that data on their end user device, you're storing data. The e-privacy rules, which have been around since 2002, updated in 2009, now required already prior informed consent for the storing or gaining of that access. GDPR came along and said, hey, consent's going to change. We've got a new definition of consent. So if you're placing a cookie or gaining access to that cookie, you need consent under e-privacy. Well, GDPR said that consent means freely given, specific, informed, and an unambiguous indication of wishes. A very precise definition really meant the opt-in, all the difficulties that Jessica was alluding to in the US world. Opt-in was something that's really quite difficult to do. So Adtech was facing new look at e-privacy, the way they collected information, and then GDPR, which came and said, well, to the extent you're processing that data, you've got to process that in accordance with the law, and there are other rules then. So there's the obtaining of the information and then using of data, and looking at how you do that across two fairly complicated sets of rules. Now, with GDPR, everybody looking at that, at the same time, somewhat unfortunately, Europe had announced, well, e-privacy, it's been around since 2002, we're going to reform that, and some rules are coming soon. So some took the view, well, I'll sort that out when I know what those new rules are. Of course, we still don't know what those new rules are under e-privacy, and we're operating under a very, very complicated patchwork of two complicated pieces of legislation with a lot of data and a lot of collection and use and sharing, Michael. So what we do know is we need transparency and clear, open and honest use around data, and the way data is collected, the way it's used, and then the way it's shared. And that's really what we've been struggling with in Europe ever since.